The other item that is very controversial and unconstitutional adopted in the law is that in accordance with the Constitution of 1996 that is now in effect, the Supreme Court of Ukraine is the highest judicial body in the country. And any attempt to whittle away as its status through the proliferation of specialized courts must be rejected. So now the lower courts are basically deciding whether they want to refer cases to the Supreme Court for a decision, taking away the authority that the Constitution grants to the Supreme Court. That's one. Now, the Constitution bars political affiliation and belonging to political parties. However, what's happening is judges may run for political office. You know, they run for political office. The former chief judge of the higher commercial court ran for office on the Regions Party list. He won, so he's now a member of Parliament. He did not resign from office, but he just went. Now, another judge from the Supreme Court ran for office from another party. He lost. So he's still a judge on the court. So you have a problem. Judges must first resign in order to run for a political office. There's another requirement that is unconstitutional that provided some trouble for the Constitutional Court, and that is a provision now in the law that judges, before they take office, must be sworn in the presence of the president. What happens if the president doesn't show up for such a ceremony? The judges cannot take their offices. So this is a big problem. That's what happened with judges of the Constitutional Court that were required to take oath of office before the Parliament. Parliament did not schedule the oath of office, so you had in Ukraine a lack of quorum for 10 months of judges of the Constitutional Court. That is a big problem, and naturally something has to be done. This provision must be changed and eliminated. The other thing is the problem, big problems, is with the High Council of Justice. There is a need to change the composition of the High Council of Justice. The recommendation is to half of the membership of 20 members should be judges rather than politicians. Well, you know that the High Council of Justice seems to be under inappropriate political influence, and this will definitely harm the selection of qualified justices. Just for your information, the present head of the SBU is a member of the High Council of Justice. Other matters in this law in the judiciary, basically that the Constitution provides for jury trials. However, the Constitution was adopted in 96. Well, would you believe that almost 15 years after that, there hasn't been a jury trial in Ukraine? The Constitution says that as provided in the law says the same thing, but then it makes it subject to procedural codes. Well, procedural codes are completely silent about jury trials, so there is no jury trial. The Constitution guarantees adversarial proceedings. There are no adversarial proceedings because Ukraine follows the European system of civil law, the inquisitorial system. So there's another thing. The other matter that has to be reviewed very carefully, and that is the role of the prosecutor general, the procurator of Ukraine. Is he a member of the executive branch and brings cases in the name of the state, or files in the name of the state, or is he has oversight over everyone and acts as a fourth branch of government, which was typical of under the Soviet Union? There's no question that there is need for reform. In my opinion, the first step in reforming the judiciary should be to amend the existing laws to bring them in compliance with the Constitution. Allowing unconstitutional laws to remain in force threatens the rule of law. Once all existing laws have been modified to be in line with the Constitution, the next step in the reform is to pass new laws that comply with the Constitution. That's very important. The decision of the Constitutional Court of September 30th, 2010 on the political reform is an abrupt change of course. Although the substance of that decision was correct, the court should have explained in full its reasons for departing from its prior recent decision on the exact subject. The failure to do so and the uncertainty created by the recent decisions threatens legal chaos. The political reform, remember I told you December 8th, 2004, was in response to the fraudulent presidential election and was called Law 222, 4 twos. That was the name of the law. The amendments resolved the electoral crisis but created all sorts of problems. The procedure of adopting the political reform were challenged. Now keep this in mind. The same procedure were challenged in 2008, and 102 legislators petitioned the Constitutional Court for review of that law. Remember, first the President Yushchenko signed that you cannot do it, while the Constitutional Court decided afterwards that they can do it 2 years later. And the court ruled that when the law becomes amending the Constitution becomes effective, it's no longer a law, but is the Constitution. So they will not invalidate the law. Okay, that was 2008. September 30th, 2010, they said the law is unconstitutional without explaining the difference between one and the other. So immediately there's a problem. There is a big problem. If the law is unconstitutional, it was challenged, goes back to the Constitution of 1996. So that means that it raises a lot of questions about all the activities from the amendment time to the present time. What happens with some institutions, and especially what happens with elections. Elections to Parliament should have been in March of 2011, the end of March. Now, by one way or another, laws were passed, and there was a recent vote that basically changed the Constitution and saying that election can be in 2012. So that gives the time, actually more time. They declared the political reform unconstitutional, but now the elections will take place in accordance with the amendments that were passed in 2004. That is for the Parliament and for the President. Very confusing. Now, that vote, by the way, of the Parliament is being challenged now before the Constitutional Court. I don't expect that we'll have much success, but it's being challenged. As you have read, there are a number of deputies that were not present, and their votes were registered. You had Deputy Arayev here, right, last week or 2 weeks ago, where he showed his voting card and said, here it is, I have it. I was not there, I didn't vote, my vote was registered. You had Deputy Mochan saying, I was in the hospital, I didn't vote at all. So now we don't know whether, they had the necessary votes to approve that change or not. So there's a problem. Another one of these decisions was that by the Constitutional Court dealing with coalitions. First, the Constitutional Court decides that a coalition must be formed by factions in Parliament. Then a year and a half later, the Constitutional Court decides that no, individuals of these factions can form the coalition. Completely the opposite. Nothing has changed except there's a new government in power. Let me just conclude by basically saying this. While the Constitution needs some improvement to bring the judiciary into line with international standards, and by the way, the international standards are quite strict, and the international organizations have been very, very critical of what's happening. If you read the Transparency International, it ranked Ukraine on the bottom third of as far as corruption is concerned, and the Ukrainians themselves declared that the judges are the most corrupt in the country of any institution. So that does not say well for the judiciary in Ukraine. Also, the Court of Human Rights expressed its opinion by basically saying that Ukraine is among the largest group of countries that does not implement the decision of its own courts or the international courts, the Court of Human Rights. So that is a big problem. In rendering decisions, judges must adhere to the Constitution and the rule of law rather than political or personal motives. In making improvements to the Constitution and laws, the legislature must heed the aim of the Ukrainian judicial system. The goal of any judicial system, whether civil law or common law, is to provide stability through the consistent application of the laws and adherence to the Constitution, since arbitrary decisions can instill uncertainty and confusion, not only in legal circles, but also in the people of a given country and the international community. So this was not a very positive presentation. I usually am more, or have been more positive in my presentations. But I like to end on a somewhat maybe quasi-positive note by making a comparison. In the summer of 2008, I was invited to speak in Buenos Aires, Argentina, dealing with the judiciary. I had 3 lectures and participated at the conference. I grew up in Buenos Aires. I went to school there, so my Spanish is quite good, which is very good right now in the United States, naturally. And I spoke in Spanish about the U.S. judicial system and some of the intricacies of my court, the Court of Federal Claims. And then after I was done speaking, naturally, I went on the floor and I was sitting there. I closed my eyes and I was listening to the presentations of the judges from Argentina and other and attorneys concerning the legal system in Argentina and some of the neighboring countries. And then for a while, I kind of opened my eyes and I asked myself a question. Am I in Ukraine again? So on that note, I will end. There are other countries that have the same problem. I don't know whether that is to console you or what, but just giving you an example. Thank you for your attention.